First of all, can I just welcome the addition of this journal to the literature on the subject. There are 2 journals on arbitration in the UK, but there aren't that many others in other jurisdictions. So this is a novel enterprise, and all I can do is wish it well. A publisher once told me that for a book or an article or a journal, the dream team is a practitioner and an academic working together. But it seems to me you've got 2 one-man dream teams as your editor and deputy editor. So I think you're in very good hands with those. Just a few points about what the journal should be doing and the way it should be organized. It's important for a journal to maintain both academic and practitioner links and input. We are differently trained in some ways. Academics tend to be trained in analysing the history of the law and looking at the reasons for particular rules. Practitioners, on the other hand, have to deal with the actual practicalities of it. And my experience has been that practitioners deal with problems that academics couldn't even dream of. So to get that joint input is really important into a journal. And I think that a journal is particularly important for this region for 2 reasons. One, I think, has been, I think both have been addressed already in what I've heard, but I'll just repeat them. The first one is that it deepens the understanding of arbitration amongst its users and perhaps will encourage even wider domestic use of arbitration. And as we all know, arbitration is, or at least can be if it's done properly, a much more efficient and effective way of dispute resolution than some court proceedings. But the second reason I think this journal is important is that it can assist Nigeria in the region to cement its place as an international forum for dispute resolution. A number of points I think I can make about why that might happen. And of course, this is for the benefit of everyone concerned. Lawyers will benefit from this, judges benefit, everyone benefits, arbitrators. The first point I would make is that Nigeria's legal system, like that of some 80 other jurisdictions, is derived from the common law. So there is no substantive reason why people wouldn't want to come to Nigeria to have their disputes resolved. The judges will understand legal principles, the arbitrators will understand common legal principles. So there's no barrier to Nigeria setting up as a major arbitral centre for the future, and the journal can help that. Second point I'd make is that Nigeria is a signatory to international conventions, the New York Convention in particular. The law is not entirely model law, but it's pretty close in many situations. And it's essential for arbitrators, judges, practitioners to be kept aware of what is going on in those other jurisdictions which have adopted the same measures. So that arbitrators facing procedural issues which have been dealt with elsewhere will know what to do, and courts reviewing arbitral decisions will be able to look at international consensus on those matters. Third point I'd make is that new issues just keep arising. I remember when our Arbitration Act 1996 was passed in England. It's not the UK Act, by the way, it's just an English Act. It doesn't apply to Scotland. We were getting about maybe half a dozen arbitration cases a year. As soon as the Act came in, we started to get about half a dozen cases a week. And we've now probably had 2,000 or 3,000 cases on the Arbitration Act 1996. So things keep happening and methods change, new devices are adopted. And you need to keep abreast of them. I'll just give you 4 examples. First of all, do arbitrators have a duty of disclosure when there's a fear of potential bias? is an arbitrator who keeps getting appointed by the same law firm, required to disclose that fact. Again, Supreme Court decision on that issue in the UK. Second issue, and this is one that's becoming particularly important in international arbitration. What is the effect of making provision for emergency arbitrators? Does that in any way restrict the powers of the courts in assisting the arbitration when there's an emergency arbitrator who can do the job? And how do you give effect to the ruling of an emergency arbitrator? And the jury is still out on that one. And there's a third point, which is actually dealt with in Orjiuka's article in the journal, which is the law governing an arbitration clause. Does it follow the law relating to the substantive agreement, or does it follow the law relating to the seat? And this is where it's particularly important to keep up to date, because although the journal has only just been published, and the article has only just been published, the law is about to change in the UK. The article sets out the reasons why it should be the law of the contract that governs, but after a detailed consultation in England, the majority view was it should be the law of the seat that determines the law of the arbitration contract, and we're about to introduce legislation to implement that. So you see how fast-moving all of this can be. I mean, there's a fourth point which affects me actually personally, which is there a distinction between jurisdiction of arbitrators, when you can challenge them for acting outside their powers, outside their jurisdiction, and admissibility, which is a decision that they take whether or not to admit particular evidence. And I was involved in an arbitration in Singapore, which was appealed up to the Court of Appeal in Singapore on that very issue. Fortunately, I came out on the winning side in that one, but you can see that these are very live issues. And the fourth point I would make is that if you look at any judgment of the English courts, of the Hong Kong, Singapore, other jurisdictions, these days they cease to be domestic. They are international judgments. Very many judges now will look at the case law in other jurisdictions, and there are many of them involved in this, even civil law jurisdictions like France and Germany. And they look at articles, they look at textbooks, and it's really important to have some sort of forum where all this information is available. And I think the last speaker pretty much said that it's important to keep knowledge current in all of this. The next point I'd make is that most arbitrations are governed by institutional rules of one sort or another. Those rules they vary from institution to institution, but there's a commonality between them. And it's very useful to be able to know how they've been, how the same rules have been interpreted in other jurisdictions. It's also useful to know what the rules are, because you might find that variations between those rules are actually quite important for particular decisions. The absence or presence of a provision in one set of rules may be completely, maybe very relevant to how you interpret other rules. And finally, there's international guidance, the IBA principles and so on. And again, all of this needs to be made available to people who are working in arbitration. So the basic point is that it's important to have a journal which brings all this information together. It's very difficult if a point arises in a particular case and you just don't know where to start. Which jurisdictions do you look to? What points do you look to? If you've got a journal which is trying to keep you up to date with some of this material in the most recent decisions, that will be really helpful to practitioners and arbitrators. The first issue that has hit my desk, it's a great start. It's got a great combination of academic articles, practitioner articles, some international, some domestic. So it's exactly the sort of thing that you need to do. This is a really great template for the future of the journal. And finally, I would say that I know that there's provision for case notes, which I've heard referred to, and book reviews, as well as articles. I think case notes are important, and what I would like to do, if I may, is to encourage those partners in law firms to give time to their associates and indeed themselves to contribute to this journal, to make sure that there's a wide range of people willing to contribute and contributing on a regular basis. And so the onus is partly on law firms to do that, because that's where a lot of the basic knowledge is. And it's also to be hoped that with the journal up and running, academics will pay more attention to arbitration and think, well, actually, this is a really rich and interesting area of law, and I'd like to be involved in it. So I think that, in summary, I think the journal is a fantastic idea. It's in wonderful hands. The first issue is absolutely excellent. And I would encourage everybody to both read it and, in particular, write for it. There will be times when editors are struggling. I've been editing a journal for 35 years, Journal of Business Law in the UK, and I've been in the lucky position of always having a year's worth of material under my belt. So if anything happens, I'm covered. But that isn't always the case with the new journal. So if editors do come knocking on your door or emailing you saying, have you got anything, please be receptive, because once this gets launched and once it gets going and once it gets recognised, it will be a fantastic addition to Nigerian legal knowledge. Thank you very much.
It's me again. I've been instructed by the bench to say a few words of thank you to Professor Merkin. As usual, he's dissected the issues. He's got the experience, as you say. I mean, I serve on the Journal of Business Law, which he has edited for 35 years. I sit on the editorial board of that as well as the arbitration editor, and I've learned a lot. So we would like to say a very big thank you to Professor Merkin for taking the time to look at the journal, to review it, and share with us his experience over the last 50 years, I would say, doing all these sort of things. And I'm sure we will take, as part of the editorial board, we will take away a lot from this session, and we would reflect on it. And ultimately, we may come back to you again and ask a favor somewhere down the line. Lastly, I would like to pass on the thanks of Professor Olawanye. I don't know if you'd logged on at the time, but you've got not just one student in the room at the moment, you've got two, because there's somebody here who you taught 33 years ago. Do you remember?
I don't remember yesterday, Hakeem.
Right, he sends his wishes. You taught him marine insurance? Yes.
Oh my gosh, Queen Mary.
Right, so once again, thank you very much, Rob, and please help me to thank Rob Merkin, KC.